Thank you for joining us for the 2018 California Employment Law Update. This is something we enjoy doing every year for clients and friends. And this year we've had a similar record number of new employment laws in California. What we are seeing that is different is that we are beginning to see the backlash in California against the anti-regulatory trend in DC, as well as efforts on other fronts such as immigration. We'll address some of those issues here today. This is a webinar we do at the beginning of every year to address the new employment laws. We at Con-Masi-El-Kerry have a full webinar series, and we invite you to join other webinars throughout the year on a host of other subjects. I wanted to first just provide very brief information about our firm. We're a nationwide boutique labor and employment firm. I'm co-presenting with our associate Dan Deacon. First off, wanted to provide some information about my background. I've been practicing labor and employment law for over 20 years. I head up the California office based principally in San Francisco. My practice is defending employers in employment-related litigation, whether it be individual actions, PAGA actions, class actions, etc. And we also, part of my practice is representing employers in Cal OSHA proceedings throughout or up and down the state here in California. And also a robust portion of my practice is advice and counsel, advising employers on a variety of employment-related issues, whether it be handbooks, personnel matters, leaves of absence, and other personnel-related issues. And now I'm going to turn it over to Dan Deacon to introduce himself.
Thanks, Andrew. My name is Dan Deacon, and I'm an associate here at Con-Masi-El-Kerry. I work out of the Washington, D.C. office, and I also work closely with Andrew on California law issues. My practice focuses on all aspects of the labor and employment law and occupational safety and health law. I represent employers in inspections, investigations, and enforcement actions involving the DOL, Department of Labor, including OSHA, and other state and local employment-related agencies. Part of what I do is I represent employers in state and federal court on wage and hour issues and discrimination matters. And I also regularly advise and counsel employers on employment law matters and assist in updating handbooks and employer policies.
All right, so let's discuss the agenda for today. We're going to discuss the new wave of California employment laws. We focused here today on the key employment laws that specifically impact private sector employers. There's a host of other employment laws that have taken effect that are specific to public sector that we have not included, given the great breadth of laws that have taken effect in 2018. We'll also address some regulations that are particularly key. And then another major issue is the local ordinances. There was a time, I recall, when there really were no employment laws on a local level in California. It was all on the statewide level or federal. We have seen a trend, particularly in the last decade and more so in the last few years, of different municipalities enacting their own employment laws. And there has been, marked differences in terms of the laws that have been enacted on a local level. But another phenomenon we're seeing is municipalities enacting laws that really are very similar to the state laws, but are slightly different. And we're seeing that with the ban the box laws. We're seeing that with the paid sick leave. And so it is creating some compliance nightmares for employers where they need to comply with both the local and the state laws and determine which to follow when there's a conflict. And so we'll address those issues later in the webinar. And then, lastly, in terms of takeaways for California, employers will have some tips for training and handbooks and otherwise changing policies and procedures in light of these new laws. But let's delve right into these topics, and starting with the new employment laws, which all took effect in January 2018. There are some laws that did take effect earlier. For example, the regulations concerning transgender protections that Dan will cover, that did take effect earlier in 2017. But let's start off with the ban the box law. And this is a law that just went into effect. There has been a nationwide trend, as many of you may be aware, of enacting ban the box laws, particularly on a local level, at the city level. And this has been in reaction to concerns about the consideration of criminal history. And it's been mostly fought at the very local level. We did have a ban the box law that was in effect a number of years ago, or went into effect for San Francisco, and we've been dealing with that in San Francisco for some time. The California law is, or has some similarities to the San Francisco ordinance, but is more aligned with the Los Angeles ban the box law. And so, for example, employers that are in San Francisco will need to reconcile the differences between the San Francisco and state laws. But just to start out with, what does this law entail? Specifically, there's really two parts. One is that the law limits inquiry into an applicant's criminal history, and that's both in terms of what you may inquire into and what you may consider in making employment decisions. And first off, an employer may not inquire into or consider an applicant's criminal history before the employer has made a conditional offer of employment. Now in San Francisco, the trigger has been when you have the first live interview, that you cannot make any such inquiry until after that interview. California has spoken, and this new law essentially prohibits any inquiry into criminal history until you've made that conditional offer of employment. And it's important that the job application not contain any inquiry into criminal history, and that there be no verbal inquiry either. You can create a separate form that would allow for this inquiry after you've made that conditional job offer. This law is far-reaching, applies to all employers with 5 or more employees. And then this law also critically has some procedural steps that an employer must go through before denying an applicant a position based on the criminal history. And this is a consideration that many employers have had already in light of guidance by the EEOC, Equal Employment Opportunity Commission, specifically guidance related to how to handle criminal history and the disparate impact that the consideration of criminal history can have on certain racial minorities. And so many employers will go through already an individualized assessment of some form before withholding a job offer based on a criminal history. Yet this law actually imposes a fairly rigid process an employer must go through. First off, the employer must engage in this individualized assessment about whether the criminal history has a direct and adverse relationship with respect to the duties of the position that's been applied for. And the factors to be considered are, first off, the nature and gravity of the offense. And so, if you're looking at a conviction that involves an act of violence or a sex crime, that's obviously going to have a lot greater sway than a sort of low-level misdemeanor conviction. You also look at the time that has passed since the offense or the sentence. So if this was something that occurred 10, 20 years ago, it may be less relevant to the job than a conviction that occurred within the last year. And lastly, a consideration is the nature of the job held or sought. And so you look at your industry. If you are in an industry such as healthcare where you have vulnerable individuals with which the employee would be have activity, have interaction, then you would likely scrutinize that criminal history much more than, say, a position where there wouldn't be such interaction. You also would look at positions such as hospitality. It could be a hotel where there's close interaction with guests in their hotel rooms, and there may be concerns about hiring an individual that has a criminal history that presents concerns for the employer. In terms of process, the employer must also inform the employee or the applicant by a preliminary decision that the employee or the applicant is being disqualified for employment, and the applicant must have 5 business days to respond before a final decision is rendered. If the employee responds, or sorry, in this case it would be the applicant. If the applicant responds and indicates that they are obtaining additional materials to be able to respond substantively, you must allow that individual to have 5 additional business days to provide that information. After that point, the employer may make a determination, but the employer must consider the applicant's response. And in terms of the substance of that written notice, it must inform the applicant of the decision, that there's been a notice of disqualification based on the conviction, provide a copy of the conviction report if there is one, and indicate that there's a right of that applicant to respond to that decision. And now the next step, after the preliminary decision, after you provide the applicant the opportunity to respond, then there's the final decision that must be in writing. Disclose the decision. You don't need to disclose the reason specifically for the decision. You must disclose the employer's existing procedures for challenging the decision or requesting reconsideration if there are any procedures like that. And then you must disclose that the applicant has the right to file a complaint with the California Department of Fair Employment and Housing. I would much prefer not to have that in the notice, but that's something that California has mandated. So in closing, it's important that employers in California not make any inquiry into the criminal background before that conditional job offer has been made. It will be really important to train your managers in HR to ensure that this does not occur even verbally, and we'll provide you some tips at the end of the webinar on that. And then also ensure that you have a process to go through in communicating a withdrawal of the offer, both at the preliminary stage and the final stage. Now, the next new law that I want to address with you briefly was what's AB 168. It concerns the consideration of job applicants' salary history. This has been another area where the local municipalities have been quite active in enacting salary history bans, and really the motivation has been over gender pay disparities, and the concern being that consideration of past salary will essentially continue the trend of gender-specific disparity in compensation. And the implementation of this new law is challenging, since it is ingrained for many employers to inquire into salary history to determine whether this person would be willing to accept the offer being made given the constraints financially that the employer may have. But given this new law, employers will need to, again, just like the criminal history inquiries, engage in sort of a seismic shift to ensure that they are their procedures are changing to ensure compliance. Now, in terms of the new law, it's rather straightforward. Essentially, it's a ban on employers seeking salary history information from any job applicant, whether it be in writing or verbally. And then it also, in tandem, prohibits an employer in California from relying on the applicant's salary history in determining whether to offer the job or determine what salary to offer. So one caveat here is that an employer may consider salary history that is disclosed voluntarily and without prompting. So that essentially means if you're in an interview with an applicant and they just off the cuff just say, this is what I want in compensation because this is what I'm earning now, and there was nothing said by the employer representative to prompt that statement, then there's no violation there. But it'll be really important for individuals interviewing applicants not to engage in inquiry that could essentially implicitly or directly prompt someone to provide this information. Another component is that employers must provide upon reasonable request the pay scale for the position at issue, and that's only if it is requested by the applicant. And that's a bit of a quandary for employers because it's the sort of information you don't want to disclose. But it's something you want to be aware of also in terms of how you're setting up the scales and how you define the pay scale. And that'll be a question for you to discuss with HR and legal in terms of how to position that for disclosure to any applicants. And now I'm going to turn it over to Dan to discuss the protections for transgender workers.
Thanks, Andrew. I'm going to, as Andrew mentioned, talk about California's new regulations, newer, I should say. They went into effect back in July of 2017, but these new regulations that expanded protections for transgender workers. California has certainly taken the lead on transgender rights in the workplace and offering more protections. And it'll be interesting to see, what other states are going to do if they'll follow suit on this level. But certainly leading the charge at a state level where the federal government hasn't provided such specific protections. So the California Office of Administrative Law approved these, as I mentioned, back in 2017, and they went into effect July 1st. And they expanded the protections for transgender workers under the Fair Employment and Housing Act. The FEHA prohibits workplace discrimination and harassment on the basis of gender identity and gender expression, among numerous other protected classifications. But these new regulations were designed specifically to address protections for transgender employees, which included access to bathroom facilities, grooming and dress standards, and the recording of gender and the name of employees. So what do these regulations actually state? Well, in a high-level summary here, the new regulations make it unlawful to discriminate against an individual, one, who is transitioning, two, has transitioned, or three, is perceived to be transitioning. So first here, the overall message here is the new regulations recognize transition discrimination, and this is completely new to the regulations, and it carries with it a host of new requirements that employers really need to be aware of. So some of you, may be wondering what the term transition means and whether it's specifically defined in the regulations. Well, it is. The regs added subparagraph F to section, I think it's 11030 of the FEHA regulations. And under that section, transitioning is defined as a process some transgender people go through to begin living as the gender with which they identify. And that includes changes in name and pronoun usage, facility usage, participation in employer-sponsored activities, undergoing hormone therapy, surgeries, or other medical procedures. So let's talk quickly about some of the requirements imposed on employers under the new regulations, some of the specific requirements that I was referencing earlier. So one, the regulations require employers to abide by an employee's request to be identified with a preferred gender, name, or pronoun. So if an employee wants to be referred by a specific name that's different from their legal name, that's something that should be respected in the workplace. There is going to be one caveat, however, and that's specifically spelled out in the regulations, and that's that an employer is permitted to use an employer's gender or legal name as indicated in a government-issued ID, even if it's inconsistent with their preferred gender or name, and that's as necessary in order to meet any legally mandated obligation. So there is some protection at that level. However, generally you should be respecting an employee's preferred name or pronoun or preferred gender as they would like in the workplace. Additionally, too, here, employers are prohibited from requiring an applicant or an employee to disclose whether the individual is transgender generally, and specifically on job applications. So you need to be careful with this and make sure you're reviewing your applications and that those check boxes aren't on there. However, the regulations make it clear that an employer can communicate with an employee about their gender identity, or gender expression once the employee initiates communication with the employer regarding the employee's working conditions. So the key here is that inquiries about an employee's gender identity or expression, they can't be a condition of employment. You can't just be simply asking the employee what their gender identity or expression is. So you shouldn't be inquiring at all into those things unless the employee brings it up first or there's a bona fide occupational qualification for having such information. Establishing that defense is going to be pretty tough under these scenarios, though, as the regulations are written. As many of you are probably aware, a bona fide occupational qualification defense is pretty tough. If an employee has a practice that's on its face excludes an entire group of individuals on a basis enumerated in the FEHA, the employer needs to prove that the practice is justified because all or substantially all of the excluded individuals are unable to efficiently perform that job. But the regulations specifically spell out here, and this is what makes it somewhat difficult, is the fact that an individual is transgender or gender nonconforming, or that the individual's sex assigned at birth is different from the sex required for the job, that cannot be relied upon as a bona fide occupational qualification defense. So next we'll go on here to grooming and dress standards. This is another new requirement under the regulation. And in there they clarify that it's unlawful for an employer to impose upon an applicant or employee any physical appearance, grooming, or a dress standard that's inconsistent with that individual's gender identity or expression, unless there's a business necessity defense. So in other words, the employer here needs to prove that there exists an overriding legitimate business interest such that their dress code practice is necessary for the safe and efficient operation of the business. Again, this is going to be pretty tough. The one key issue here is that the regulations are somewhat silent as to how employers should treat employees who don't identify as either male or female. So employees that are going to be, or employers that enforce gender-specific dress codes, they could be liable for discrimination against an employee who, for example, doesn't identify as either male or female, non-binary, or someone who identifies as both male and female, or who is in transition. So this is an area that you need to be really careful and take a look at your policies and see if there's a strict gender grooming dress code, and it's something that you're going to need to address now. So finally, this is one of the last points that we'll make under the new regulations, and that's related to access to bathrooms and other facilities like locker rooms. So the employers in California now need to permit an employee to use bathrooms or other facilities that correspond to their gender identity or gender expression, and that's regardless of the employee's assigned sex at birth. Employers cannot require an employee to use any particular facility. You're going to need to be required to provide feasible alternatives, and that's specifically spelled out in the regulations, feasible alternatives to protect transgender employees' privacy, and that includes locking toilet stalls, staggered schedules for showering, and or shower curtains. So while these new regulations require employers to permit employees to use facilities that correspond to their gender identity or gender expression, regardless of their sex at birth, they don't offer much guidance with respect to providing facilities, again, for employees who don't identify as male or female. If an employee has that gender identity that's neither male or female, is that employee permitted to use whatever restroom the employee chooses on any given day, regardless of how that employee presents? It's unclear. So that's one issue that we'd like to highlight, that the regulations don't address. So an employer can, however, this is one caveat that is spelled out as well. While the regulations recognize employers can make a reasonable and confidential inquiry for the sole purpose of ensuring access to comparable, safe, and adequate multi-user facilities, the employer cannot require employees to provide any proof of medical treatment or procedure or provide any sort of identity document to use facilities designated for use by a particular gender. So you can't, particularly ask someone for those specific documents confirming their gender identity or anything like that. In addition to multiple user facilities, the regulations address required signage for single-user toilet facilities. And these must be identified as all gender toilet facilities. So the regulations specifically provide that employers, they need to use gender-neutral signage for all these facilities. And you see the terms on the slide here: restroom, unisex, gender-neutral, or all-gender restroom. So it's important to note that, also federal agencies during the Obama administration adopted similar positions concerning transgender employees' access to bathroom facilities, including the EEOC and OSHA. And whether that's going to change under the new administration, we'll wait to see. But there is still guidance out there on some of those issues related to single-user facilities and signage. Next, I'm going to talk about Senate Bill 396, and California further strengthened some protections for transgender employees by ensuring that supervisors are properly trained on gender identity and sexual orientation harassment. So just a few months after the amendments to the FEHA regulations went into effect in July 2017, which expanded those protections for transgender individuals, Governor Brown signed into law what we have here, Senate Bill 396, and that goes even further in facilitating a workplace free of harassment and discrimination by requiring employers to include gender identity and expression and sexual orientation as subject matters for mandatory harassment training for supervisory employees. So as you are all probably well aware, existing law already requires employers with 50 or more employees to provide all supervisors 2 hours of training regarding sexual harassment within 6 months of becoming a supervisor and every 2 years thereafter. So as a component of this training now, you're going to need to update that training and make sure that it includes a discussion on harassment based on gender identity, gender expression, and sexual orientation. And one other keynote here is that the training needs to be performed by an individual with knowledge and expertise in these areas, and it needs to include some practical examples. So that's a best practice anyway, and you should always make sure that the person providing this training is well versed in the topics and is able to provide those specific examples. So as of January 1st, 2018, this is something new, roughly about 3 weeks ago, employers are required to also affix a poster developed by the California Department of Fair Employment and Housing regarding transgender rights somewhere in a prominent place and accessible location in the workplace. And that poster is titled "California Law Prohibits Workplace Discrimination and Harassment," and you can all find that on the Department of Fair Employment and Housing website. If any of you guys need a link to that, just please let us know. All right, next I'm going to go over a couple other notable employment laws that are important for California employers going forward in 2018. And first we're going to start with Assembly Bill 450, which pertains to immigration worksite enforcement. So several years ago, California enacted a law prohibiting employers from engaging in or directing another person to engage in unfair immigration-related practices against a person for exercising a specific right, certain specific rights. And that included retaliating against employees that were suspected of being undocumented. So the law makes clear, however, that unfair immigration-related practices do not include conduct undertaken by the employer at the express and specific direction of immigration authorities. So California increased some protections for employees here with Assembly Bill 450, and it's really designed to preclude employers from voluntarily cooperating with an immigration agency in worksite enforcement actions. Specifically, it prohibits employers or other persons acting on the employer's behalf from providing voluntary consent to an immigration enforcement agent or another enforcement agency entering non-public areas of your workplace, unless that enforcement agent has a warrant and a legal basis to be there. The bill also prohibits employers from providing voluntary consent to immigration agents to access, review, or obtain employee records without a subpoena or a court order. Again, this just went into effect 3 weeks ago, and it's very relevant right now, especially considering the recent announcement by the U.S. Immigration and Customs Enforcement plans to do raids, especially in the Bay Area. So the bill also requires that employers post notice in the workplace of any inspections of I-9 employment eligibility verification forms or other employment records conducted by an immigration agency, and that's within 72 hours of receiving notice of the inspection. So also by July 1st, 2018, so in about 6 months, there's going to be a template posting created by the California Labor Commissioner that employers can use for this purpose. So keep an eye out for that form notice and be sure to review it when that gets finalized. In addition to posting and providing that notice, the employer is required to provide affected employees a copy of the immigration agency's notice regarding the results of the I-9 form inspections or other employment records within 72 hours of receipt of that notice. So, as the last 2 slides kind of covered, there's valid ways, of course, in which immigration authorities can obtain requested information, and I just want to make that point clear, and we're going to go over some of the practical tips at the end. But for instance, immigration authorities can obtain records and documents based on a valid subpoena, and again, I mentioned that they can be at the workplace in private areas so long as they have a warrant. But this is much different from voluntarily providing the government documents without hesitation or allowing them into your workplace voluntarily and letting them run around. So someone in the company should definitely be designated to handle these immigration matters, and the request for information, it should be immediately refer to that person, and legal counsel should likely probably get involved. But again, we're going to cover those more in detail when we get to the practical tips. For purposes of this slide, we're just talking about some of the penalties. And the California Labor Commissioner and the Attorney General have exclusive authority to enforce these provisions. And as you see on the slide here, the penalties are pretty moderate, $2,000 to $5,000 for a first-time violation, and then $5,000 to $10,000 for each subsequent violation. Another pretty significant update on enforcement powers and investigation powers is the update to the Commissioner of Labor's investigatory powers under Senate Bill 306. And specifically, that authorizes the Division of Labor Standards Enforcement of the Labor Commissioner to commence an investigation into discrimination or suspected retaliation with or without receiving a complaint. Previously, the Division of Labor Standards Enforcement had jurisdiction only after receiving an employee complaint. But now, any suspected or discrimination or retaliation, really, it only needs to be suspected. Otherwise, there's a good cause to suspect it. So specifically, upon finding reasonable cause to believe a violation occurs, the Labor Commissioner can petition the Superior Court for injunctive relief that can compel an employer to hire, promote, or restore an employee or former employee to their position. And they can potentially recover monetary penalties as well, and the agency's reasonable attorney's fees. So this is pretty significant authority here. The bill itself also allows an employee bringing a retaliation claim to seek injunctive relief upon a showing that reasonable cause exists to believe that they've been subject to adverse action for bringing a claim. However, this injunctive relief, and this is key here, that it doesn't prohibit an employer from otherwise disciplining or firing an employee for conduct that is unrelated to the retaliation claim. So if there is a valid basis for terminating that employee, regardless of a retaliation claim, then that is a defense. Two here, the bill also authorizes the Labor Commissioner to issue citations directing specific relief to persons determined to be responsible for violations, and create certain procedural requirements in the workplace. So with regards to some of the penalties here, if an employer willfully refuses to comply with an order of the court under this section, or they fail to hire, promote, or otherwise restore that employee or former employee to their position, the violation is actually subject to a penalty of $100 per day for each day the employer continues to be in noncompliance with that court order, and that's up to a maximum of $20,000. So the penalties here can be pretty significant for noncompliance, and those penalties will actually be paid to the affected employee. Finally, the last one here that I'm going to cover before I turn it back over to Andrew is California's update to its Military and Veterans Code. So Section 394 of the California Military and Veterans Code previously prohibited various types of discrimination against enlisted officers or members of the military because of their membership in the military, including with respect to employment. So the bill here, Assembly Bill 1710, amends Section 394 to expand those protections afforded to service members by broadly prohibiting discrimination in the terms, conditions, or privileges of employment. And this expanded scope of the anti-discrimination law that was already on the books applies to individuals in both the public and private sector. And notably, like all other charges in California, employees first need to bring a complaint of discrimination based on their military service through the California Department of Fair Employment and Housing or through the EEOC. So really the practical, let me go back one more. The practical effect of this bill is really just to conform the California state law to USERRA, the federal law providing certain protections for service members in civilian jobs. And in practice, the bill shouldn't really have that much impact on employers, only slightly modifying the existing discrimination laws by expanding the definition of actionable discrimination based on military membership with respect to the terms, conditions, or privileges of employment. But in reality, this is just updating the California law to conform to federal law at this point. And with that, I'm going to turn it back over to Andrew to cover parental leave for small employers.
Thank you, Dan. So the next subject is the parental leave law. California has made many legislative efforts to enact parental leave or other forms of leave that apply to smaller employers. There's been pushback on that. This year it has passed, and it will have a significant impact on smaller employers. As most of you are aware, the Family Medical Leave Act and the California equivalent, the California Family Rights Act, apply to employers with 50 employees or more within 75 miles, and those two laws provide leave for an employee's serious health condition or that of a designated family member, and also for certain types of parental leave. So this law, the key here is that it applies to smaller employers with 20 or more employees within 75 miles, and it's narrowly tailored to parental leave issues, not as broad as CFRA or FMLA. And the other key consideration is that if your business is already subject to the FMLA or the CFRA, you do not need to comply with this new law. So essentially, the type of leave that is required is time to bond with a new child within the first year of the child's birth, adoption, or foster care placement. So it's narrow in that scope. The type of leave is, that's a type of leave, but it's 12 weeks of leave that is required, and it's unpaid leave just like the Family Medical Leave Act and CFRA. To be eligible for parental leave, there's a similar qualifying factors like the Family Medical Leave Act. The employee must have worked 12 months with the employer and have completed at least 1,250 hours of service by the time the leave is taken. And as I mentioned, the worksite there must be 20 employees within 75 miles. Including the sites where the employer operates. And another consideration is that employees that are eligible for this small employer parental leave must be allowed to use at their election any accrued vacation time, paid sick time, or other accrued paid time off during that parental leave. So although it's unpaid, they can use their accrued paid time off that's on the books. And then the last consideration I wanted to address was health care. This new law treats health care payment the same as under FMLA and CFRA, in that the employer must continue the premium payments with the employee paying his or her own share during that leave period. However, the law does make clear that the employer may recover the premium payments as paid during the leave if the employee does not return after the expiration of the leave. But the caveat is that the reason for not returning must be unrelated to any serious health condition or other circumstances beyond the employee's control. So that's the gist of this new law. Let's move to another key law, particularly for those in construction, trade, or where they have subcontract relationships, or it's actually not just construction, it can be in a variety of settings, but it's AB 1701. And that involves direct contractors' liability for subcontractor wage violations. There has been a trend in California to hold primes or direct contractors liable for the wage violations or other infractions of their subs. And what has happened is you've had situations where there may be a reputable prime contractor who is then subcontracting out to a variety of small contractors trying to get the best financial arrangement. As a result, they might get companies that cut corners and result in a number of different wage violations. And I've seen this happen quite a bit in practice, particularly the use of staffing agencies, also, of course, with some contractors. So what California has done, it's onerous and it changes the landscape quite a bit for contractors, but the contractors now can have direct liability for wage claims by the subcontractors. And there are some tools that are given to direct contractors to address their enhanced obligations here. But just starting off, to clarify, this law applies as to any contracts entered into or after January 1, 2018 between a direct contractor and a sub. And the contractor, the contract must be in the state and involve the erection, construction, alteration, or repair of a building structure or other private work. So, it's primarily a construction environment. And the law also makes clear that a direct contractor's liability is limited to unpaid wages, fringe, and any fringe or other benefits. It does not include penalties or liquidated damages. So if there is a claim under the Private Attorney General's Act for penalties, arguably that would not apply, and that's at least one favorable element here. And the other key point here is that the law does give the contractors the remedy to request from the subcontractor information about the subcontractor's work on the project, its employees' payroll records, specific information about its employees, so that you can essentially, as the direct contractor, conduct an audit, as it were, to determine whether the subcontractor is in compliance. Now, the failure of the subcontractor to provide the information that's requested does not remove all obligation by the subcontractor and somehow void any obligation it may have under the contract. But what it does do is it allows the direct contractor to withhold disputed sums until the subcontractor provides the information that's been requested. So any contractors will need to update their process accordingly. It's also key that the DLSE is authorized to bring in action to enforce here, as well as any third-party employee, including any joint labor management cooperation committee. So, let's move to the next issue. One law that has already been around for a while in California involves essentially whistleblowing protections for healthcare workers. And so anyone in the healthcare industry is likely aware of this law. The change has been in the penalty structure. Existing law prohibits healthcare facilities from retaliating against an individual who has presented a grievance or participate in any investigation or administrative proceeding essentially related to the quality of care, services, or conditions at the facility. There's a few other circumstances that may be triggered, but essentially the gist of this new bill, AB 1102, is that it increases the civil penalties assessed against healthcare facilities for whistleblowing activities. Previously, the willful violations were where there is some recklessness or other conscious state presumed in connection with the violation. Those violations the penalties have gone up from $25,000 to $75,000. That's significant. The civil penalty of $25,000 remains the same. So you could have a case where there's an assessed willful violation where you have a total penalty of $100,000, and that doesn't include any potential relief for lost wages. So it's a significant additional penalty that's been assessed, and it's important that healthcare facilities have the proper whistleblower procedures in place to ensure that they can address and defend against these sorts of claims. Now let's transition over to new municipal regulations. Because of the limited amount of time remaining, I'm not going to go over all of the minimum wage rates. They're quite a bit, but you can see that there was a time when California was really focused on the state minimum wage. We had the federal minimum wage. They weren't that too far apart. And then we've had the cities all enacting their own minimum wage, largely reflexively to the increased cost of living. And so as you can see from this chart, we have, as we proceed through it, we have, $12 to $14 in minimum wage indicated on the first chart. These are the standard minimum wage rates. The state minimum wage is, as of January 1st, is $10.50 per hour for employers with 25 or fewer employees, then $11 per hour for larger employers. And then you have all these different municipalities that have higher rates. And as we go through the chart, you can see how this varies. And so if you have operations up and down the state, you'll want to make sure you're aware of the rates. These are the rates that went into effect as of January 1st. There will be some increases in certain jurisdictions mid-year. And so just breezing through here, you can see the variation, from $11 up to $14, $15 in Sunnyvale. But let's transition over to the municipal ordinances. As many of you are aware, San Francisco and Los Angeles have led the way on employment laws. There's other cities that have also become involved, such as San Jose, San Diego. But I'm going to highlight some of the key new laws by some of the larger cities. San Francisco, what's important to note is that San Francisco has its own law prohibiting consideration of salary history. It's closely aligned with the state law, that you'll want to make sure that you're in compliance with both San Francisco and state law. That law does not go into effect in San Francisco until July 1st. It's a bit frustrating that we have San Francisco enacting a law that's already being enacted on the state level. You would think a city would just defer to the state, but that's not happening, and that's been a trend. And then the other important consideration is the San Francisco Paid Parental Leave Ordinance. There's been a phased implementation by employer size, and now as of January 1st, the leave applies to employers with 20 or more employees. So that law essentially provides 6 weeks of wage replacement. There's a formula they have developed for employees that are taking time off for paid parental leave. And then another law that is important to consider is the lactation accommodation law in California. It's new. It is closely aligned as well with the state law that requires that accommodations be made for employees that need to express milk in the workplace. The key difference with the San Francisco law is San Francisco has provided very specific guidelines for the type of space that must be provided to the employee for the purpose of expressing milk, whereas the state law is not quite so clear. So because the audience is from various different locations in California, I'm not going to spend too much time. I'm going to skip from the San Francisco ordinances, move now to Los Angeles. Los Angeles does have certain ordinances that apply to hospitality industry hotels. It's important to consider, which I haven't included in this PowerPoint. There's also a paid sick leave ordinance in Los Angeles that as of July 1st of last year applies to employers with 25 or fewer employees. And San Francisco has its own paid sick leave law as well. And again, that's an area where you'll want to make sure that your policies are in compliance with both the local ordinance as well as the state law. And there's also a ban the box law that passed in Los Angeles. It's interesting, San Francisco has had a ban the box law for quite some time. It's just passed in Los Angeles. The San Francisco ban the box law is similar to the state law in that the inquiry into criminal history is prohibited until there's a conditional job offer, whereas San Francisco's law has been specific to any live interview. It's not until there's a live interview that you can inquire into criminal history. So for example, in San Francisco, it will be important now to change your procedure so that you don't engage in that inquiry into criminal history until after a conditional job offer is made, given that the state law is more protective of employees, and that is what we'll control. So we wanted to conclude the webinar with some takeaways for California employers. You probably have gathered a number of areas where you already want to revise your written documents, training, procedures just generally. But one area that we did want to address at the outset was job application forms. You will want to remove any inquiry into criminal history or salary history from that document. That will be very important. You may want to develop a form that can be provided to employees after the conditional job offer is made that inquires into criminal history. You will need to, however, ensure that you do not inquire into categories that are prohibited under California law, and that would be such as convictions that have been expunged, marijuana convictions over a certain period of time. There's a whole host of categories. And then also, if you are in a jurisdiction like San Francisco, there's limitations under San Francisco law as well. And then, as indicated here, you'll want to defer any inquiry into criminal history or conduct even a criminal background check until after the conditional job offer has been made. And then it'll be important to update your employee handbooks. For those of you that have obligations to provide paid parental leave as a result of this new California parental leave law for small employers, you'll want to incorporate that policy into your employee handbook. We would also recommend updating your EEO statement in the handbook to include transition discrimination. It should already include prohibition against discrimination based on gender identity and expression. And then, as Dan already discussed, there's a number of protections now for transgender employees. Some of them are intuitive, some of them are not as intuitive, but I would recommend including in your handbook at least some language that puts employees on notice that they do have a right to request accommodations, as transgender employees. And it could be a more detailed policy, or it could be something very to the point that just indicates that they should contact human resources to request any accommodation. I would recommend that there be someone sufficiently savvy and skilled and knowledgeable of this new law to handle the accommodation request. And lastly, we addressed this, the paid parental leave should be incorporated. And then if there's any municipal ordinances that directly impact your workplaces, to make sure that those laws are addressed in some form in the handbook so employees are on notice. And the idea typically with the employee handbook in terms of incorporating these various different legal obligations is you put employees on notice that they have that entitlement, and practically speaking, then they're aware of it and they can come to you and be more knowledgeable. But from a legal standpoint, if you have a lawsuit later and they claim that they were never told about this entitlement that they had, and in fact indicate that somehow they were discouraged from taking leave or electing this form of entitlement, you can point to the handbook as your Exhibit A in the lawsuit and say, look, this employee knew about this entitlement, simply never came forward, never made a request for the leave. Now I'm going to turn it over to Dan to discuss takeaways involving training.
Yep. Great. We only have a couple more slides here, and I'm going to be considerate of your time and try and get through these pretty quick. But as Andrew mentioned, I'm just going to talk about training. What do a lot of these new laws and the regulations have in common? And that's training. Some specifically require it, and for others, it's just a best practice that you should be doing. Specifically here, employers should be training managers and supervisors on proper hiring procedures, especially in light of these new regs. And that includes refraining from inquiring into job applicants' past salary and criminal history before the conditional offer. Also, employers should consider conducting refresher training on permissible interview questions under FEHA and the anti-discrimination statutes. You should also continue to train and educate your recruiters and managers, supervisors regarding their obligations to comply with other anti-discrimination laws with respect to, as we discussed, the candidate service members, and ensure that those provisions are incorporated into your policies and make sure that they're consistent with USERRA as well. Next here, we'll talk a little more in detail about gender identity and expression. Obviously, that's one of the big new laws that you're going to need to be keenly aware of. So it's important, especially under these new regs, to make sure supervisors are trained on gender identity concerns and how to refer to transgender employees by their preferred name, gender, and pronoun. Employers should be implementing procedures to accommodate those requests to change working conditions for transgender employees, and ideally those should be referred directly to HR. And this is especially important with respect to bathroom or locker room and facility accommodations at your workplace. HR should be involved almost immediately. Finally, it's also worth reviewing or inspecting your workplace. Just make sure that any single-user facilities are gender neutral and they have that gender neutral signage attached to them. And then the last slide here, the last takeaway for California employers today is you should be developing internal procedures for handling investigations or inspections by immigration authorities. And I kind of already alluded to this previously when I was going over those slides. But you really just need to know your rights as an employer under these new regs. First, you want to have a plan for who in the workplace, who on staff is going to handle any government officials that show up at your workplace or any requests for documents. Establish who that point of contact is now, whether it's a specific manager, the owner, CEO, and instruct employees who that appropriate contact person is. And as I mentioned, you should probably get legal counsel involved, especially if there's a legal question involving a warrant, subpoena, anything like that. But also, anyone showing up at your workplace is only allowed to enter the public area without your permission. If it's a private area in the workplace, the person that shows up, the immigration agent that shows up, needs to have a judicial warrant and make sure that they have one. So any areas that are off limits to the general public in your workplace are also off limits to federal officials unless they have that warrant. So ask to see it. It should be signed and have a list of names of the employees that they'd like to see, or the documents that they're requesting if it's a subpoena. You don't have to provide them any more information that's requested, and this is where legal help comes into play. You want to make sure that you're complying with that subpoena or that warrant without overextending or oversupplying what's requested. And then finally here, that last bullet is you want to update your sexual harassment training for supervisors to include a component on gender identity and gender expression and sexual orientation harassment, and make sure that the person providing that training is knowledgeable on the subject matter and is able to provide examples. And a last note, just make sure that the mandated poster under Senate Bill 396 is located in a conspicuous spot somewhere in the workplace for all the employees to see.
Thanks, Dan.
Yep, go ahead.
Yeah, no, I just wanted to go back and address a couple of the issues from the last slide, and I thought that was really well stated. Regarding the new law on immigration enforcement, there have been, at least in the San Francisco Bay Area, announcements by federal immigration of raids in this area, and there have been, I've worked with trade organizations that have been particularly concerned, and there's been guidance that has been issued to establishments, to employers, and I think what's most important is that that employers be prepared for the possibility of an immigration raid and know how to appropriately respond. And employers are in a bit of a pickle because they need to comply with federal immigration law, but they also don't want to run afoul of state law. And there is an argument that this new state law on immigration enforcement is susceptible to challenge, but as of the present, it is the law, and so employers have a fine line of complying with a proper judicial warrant and subpoena, but at the same time not cooperating such that they could run afoul of California law. And so it's such a sensitive area that we would recommend having some sort of training in advance in identifying the point people at the establishment. And Dan has stated it well that if it's a public space, the immigration authorities have leeway in terms of access, but if it's a private part of the establishment, then you have a right to request the warrant that's judicially signed, and as well as, and then there's certain obligations you have under California law in terms of disclosures. We did have one question about the training requirement in California for supervisors. There is a requirement for employers with 50 or more employees to provide that training. It's that requirement of 50 or more employees is in reference to any employees, whether it be within California or outside of the state. And so if you're a nationwide employer that meets that threshold, but you have a few employees in California, you'd likely have an obligation to conduct that supervisor harassment training. In any case, we will provide a copy of the slides to everyone. We know there was quite a bit of content to cover in a relatively short period of time. And then, of course, we're happy to discuss any employment issues you may have, and our contact information is on the presentation here. Thank you for joining us, and if you would like more information about our webinars, you can go to our website, and there you can sign up for a sort of annual pass. It's complimentary, where you would receive notice for all of our webinars throughout the year, or you can especially register for certain webinars that might interest you. Thanks for joining.